Hi everyone, and thank you so much for joining me. So what happens to your real estate after you die? Who decides? How is it handled? How long does it take? To answer these and other burning questions, I have with me today my good friend and trusted probate attorney, Rob Cohen of Cohen Law, to discuss the probate process, what it is, who it involves, and how to navigate it like a pro. Rob, thank you so much for being here. I'm so excited for our conversation.
Thank you for having me. I only hope I can live up to the level of excitement you have, because a lot of people find this to be a fairly dry subject.
Well, knowing you, I know it's not going to be dry. It's super, super interesting stuff. And I mean, the fact is, it's real life. You know, you have dedicated the last 20 years of your practice to helping people through a very real, emotional, and oftentimes challenging reality of life, which is death. And I think this video is going to be really important because a lot of people are under the misconception that the probate process has to be really complicated and very difficult to navigate, but it really doesn't have to be. Having worked with you, I know this. So, you know, let's start with the basics here. You know, talk to us. What is probate? And kind of guide us through some of these basics to show people it really doesn't have to be as complicated as they think it is.
I want to focus on a word that you used. It's a process. A lot of people, when they come to me, they're at their darkest times. They've lost somebody who's very close to them. Not only are they dealing with the issue of grief, because they usually call me within a week or 2 weeks after somebody's passed away. Likely they haven't dealt with the grief yet, but then they're panicking about this unknown out there that they're now going to have to be facing. They're going to have to deal with. Something needs to be done. Is there a time frame? Is there a deadline? How quickly do we have to do this? In a lot of instances, I have to tell them, first off, it's a process. It's a step-by-step. I know the process. I don't expect you to know it. I know it. But the other aspect of it is I want you to take the time now to grieve, because people will get wrapped up in the process to the point where they defer the grieving process. And certainly in the matters where I've had litigation come out of the process, which is rare, but it does happen, the litigation ends up consuming that person's life for what could be many years. Wow. And then when it's over, they realize they didn't have the opportunity to grieve, and that's when it all kind of settles on them that they haven't had that opportunity. So when I meet with people, and I typically get calls from them after somebody passes away, there's always that question of what I do now. My number one recommendation is you got to grieve. That's what you need to focus on. There aren't very many deadlines, there aren't very many urgencies that come up immediately after somebody dies. There are a handful, and if they arise, we deal with them. But I don't want people to come to me a week or two after somebody's passed away. Maybe they haven't even had the funeral or the memorial yet, and they're asking me, we need to get stuff done, what do we do? My number one recommendation is you gotta grieve, because it's a process and it takes time and it takes energy and it takes focus and it takes patience.
That's one of the many reasons I love working with you, and it's one of the things that I've heard a lot of our mutual clients say about you is that you don't lose sight of the humanity of this. You know, yes, it does involve business dealings, real estate, potentially litigation, money, family infighting, you know, in some circumstances, but you really do focus on the human element. And part of that is really giving the time to the individual or the family to really process things internally, which I'm sure also helps them with the decision-making process as you guide them through the more technical pieces of a probate, I would assume.
Absolutely.
Yeah.
In a lot of instances, I'm the first lawyer that some of these people have ever spoken with or met with. And I congratulate them. I say, well, good for you. You've gotten this far in life not having to deal with a lawyer, because, look, between you and I don't like dealing with lawyers either. But it's a scary thing.
Yeah.
You're dealing with the passing, you're dealing with the grief, you're dealing with the unknown, you're dealing with the process, which 9 out of 10 people on the street, or if not a smaller percentage than that, don't really understand, because it's not publicized.
Right.
You know, the probate process isn't something that you see TV shows made out of. Law and Order isn't covering probate court. People know what beyond a reasonable doubt, they know what a jury is, they know about acquittal or guilty, not guilty, things like that. But as far as you know, a probate order, as far as the process of dealing with creditors, the process of trying to sell property that's in the name of a decedent, the difference between a will and a trust, a lot of them don't have that level of even just general knowledge. And so when they're coming to me for something like this, sometimes they look like a deer in the headlights, really not understanding or knowing what to expect.
Yeah, which I think this is the perfect segue into kind of the meat and potatoes of this conversation. Let's really bring it down to basics, because there is just so much jargon. I mean, you use some of the words, you said decedent, beneficiaries, will, trust, that the jargon alone could be enough to make somebody's head spin, So let's start with just the definition of probate. What is this process? And let's talk about also some of the players in it, the decedent, the beneficiaries, the administrator. Give us like that basic rundown to help the viewers understand a framework of what's involved.
So a probate is a court-supervised process that has multiple parts. One is to determine who beneficiaries are, the people who will ultimately inherit when the process is completed. It determines if there's a will and whether the will is valid. It determines what the assets that were owned by the decedent that are now subject to the probate administration are. That's called the estate. And it's dealing with creditors, determining who those creditors are and whether they have claims that are legitimate or not legitimate or illegitimate for that word. So that's really the court-supervised aspect of it, is addressing those different factors. It takes the form of a court process, so it does get managed by a judge. The level of involvement that the court actually has is really determined on some of the circumstances, and it's a little bit more of the nuances of the administration. But it begins with the request that somebody be appointed to administer the estate. Now, the administrator is basically the person who will stand in the shoes of the decedent, the person who passed away, and act on their behalf to marshal the assets, so acquire all the assets, get them appraised, take control of all of them, determine who the creditors are if there are any, and then ultimately determine whether through the process of the reading of the will or the California Probate Code, if there is no will, who the ultimate beneficiaries are. In the fairly run-of-the-mill probate administration, you being the matter itself, the administration itself, may only be in court 2 to 3 times. This isn't a situation where the court has to approve everything that happens. Typically, the court's involvement is at the outset, appointing the administrator, determining who that person should be, and then either confirming the sale of real property, or if you can avoid that, then the final appearance, which is where the court approves conclusion of the administration and distribution of the assets to the appropriate individuals.
Got it.
So that's really, when people think of probate as a court-supervised process, they think every time something happens, we need to get the court's approval. The answer is no.
Okay, well, that's definitely good to know. Starting with the administrator, who decides who the administrator is?
If there's a will, then the will is submitted to probate as part of the initial petition, and the request is the person, if the will names an executor, that person would be appointed to be the executor of the will. The terminology is basically interchangeable. There's an administrator, a personal representative, or an executor. The only distinction is if you're the executor, it means there's a will. But all three have the exact same duties, and that's why I use the terms interchangeably. When there's a will, only executor. If there's no will, administrator or personal representative. So if you have a will, the will typically will name an executor to act, and that individual will submit the will to probate and seek to be appointed as the executor of the will and to be the personal representative of the estate. If there's no will, or if the will doesn't name an executor, then the California Probate Code actually has a hierarchy of priority for appointment. And so you would just use whatever the probate code says. It starts out with a surviving spouse, then it would be children if they're above the age of 18. If there are no children, grandchildren above the age of 18. If no children or descendants of the decedent, then it would be the parents. If no parents are alive, then it would be siblings, cousins, aunts, uncles, etc.
So there's a definite formula that is followed in the event that the will has not named an executor or administrator.
Correct.
Okay. Or if there is no will.
Or if there's no will.
Okay,
yes.
so those are the two circumstances. So what happens next? The administrator is appointed. What's step number 2? What responsibilities does this administrator have that would be the next steps that they'd need to take?
The next steps are to marshal all of the assets and have them appraised, and to notify creditors.
So when you talk about assets, we're not just talking real estate. It could be other personal property like cash in a bank account or stock holdings or jewelry, family heirlooms, that kind of stuff
Yes.
as well?
Yes.
Okay.
Any assets that would be subject to the administration. Now, there are assets that an individual may own that are not subject to a probate administration. Those could be assets that they own in joint tenancy, such as real property. Owning it in joint tenancy with right of survivorship means that the decedent passes away, the other joint tenant automatically receives the entire piece of the property, so that would not be subject to a probate administration. If there are assets which have beneficiaries designated, like life insurance, IRAs, 401ks, those assets, upon death of the holder of the asset, would automatically be distributed to the beneficiary, so those would not be subject to the probate administration. And any other assets that are either owned by the decedent but have some sort of a designation or a payable on death. If there are assets such as those, they don't go through the probate administration. Probate administration, as far as the assets, is real property that they own in their individual name or as a tenant in common, bank accounts that don't have beneficiaries, automobiles, priceless works of art, things of significant value. Obviously, personal property, although in a lot of instances, personal property doesn't typically have a lot of value. Furniture, bed sets and things like that typically aren't going to have significant value. But the responsibility of the administrator upon being appointed is to secure all of these assets. So if there's a real property, it's to change locks, it's to lock the property down, it's to make sure there's no trespassers or squatters, things like that. As far as liquid assets, cash and things like that, the administrator can open up a brand new bank account in the name of the estate. So it's the administrator as the administrator for the estate. And then he or she will go to the banks where the decedent had cash accounts and liquidate those accounts and deposit those funds into the estate account. So now they're part of the estate administration.
So administrators appointed, they marshal all the assets, get everything appraised. So now we know what the estate is worth.
Yes.
Essentially. Real estate, personal property, all that kind of stuff. Okay. And so now that the administrator has determined through various professionals what the estate is worth, following step after that?
Well, during this period of time is when they're notifying the creditors. So the administrator has a responsibility to notify all known or reasonably ascertainable creditors. Those are any individuals or entities that may have a claim against the decedent, somebody that the decedent owed money to, credit cards, revolving lines of credit, things like that.
There's a mortgage on the house, for example? Okay,
correct.
That also.
All of these potential creditors get notified, and they at that point have a 4-month period of time within which they can make a claim against the estate for repayment of that debt. And during that 4-month period, if any creditors submit a claim, the administrator reviews them, determines if they're legitimate and should be paid, determines maybe they're not legitimate and should be rejected, and then acts at that point to either allow them or reject them. If they're allowed, then the intention is to pay them. If they're rejected, that starts a new clock for the creditors to then take steps to pursue their claims if they believe that they were rejected improperly. But during this period of time, the administrator is acting on behalf of the estate. So if there's business interests, the administrator is taking control of the business, potentially running the business, or at least determining what needs to be done with the business, whether to sell it, liquidate it, whatever it may be, and also taking possession and control of real property and then determining what to do with the real property. If there's a will, then we know who the beneficiaries are. The will may instruct what to do with the real property. It may say the real property is to be kept. It's supposed to be allowed for my daughter to live in until he or she passes away, or I want this to remain my family home so everybody can continue to live in it. If the will has those types of instructions, then the administrator is responsible basically to follow those instructions. If there's no instructions or if there's no will, then the administrator at that point has the option to dispose of the real property if he or she chooses to do so. If there's a way, a mechanism to do so, if there's a reason to do so, if there's a benefit to do so. The administrator is a fiduciary, and so his or her responsibility is to act in the best interest of the beneficiaries, those people who would inherit, and also to act, unfortunately, in the best interest of creditors, so not to take a position that will be detrimental to legitimate creditors.
Right.
And so at that point it may be, in a lot of instances, as you know, here in Southern California, a lot of homeowners, that's the mass mass part of their estate. That's the largest asset that they own.
Right.
There may be cash, but it certainly isn't likely to be of the level of the value of the real property. There may be debts that need to be paid. Certainly there are fees and costs associated with the administration that need to be paid. And it may be determined by the representative of the estate, the administrator, that the property needs to be sold to get out from a mortgage, to get out from maybe delinquent property taxes, to avoid the issue of having to continue to maintain those expenses, while also creating cash that can then be utilized to pay these expenses and then distribute ultimately to the beneficiaries.
Do you find in your experience, as far as the real estate is concerned, that the administrator usually would opt to sell the real property as a last resort? Or is it just really on a case-by-case basis, depending on how much debt, for example, the decedent has, or if there are minors that were relying on certain income that the decedent was providing for the family? I mean, how does that, can you delve a little bit more into that decision-making process?
Yeah, there's numerous factors that play into it. I would say the number one factor is who's going to ultimately be inheriting. Because if you have multiple people who will inherit, whether it's the will that says I divide everything amongst my 3 children, or there's no will, so under California law it gets divided amongst my 3 children if we have a decedent who is unmarried, you're looking at a situation where if you keep the real property and distribute it to the beneficiaries, you now have each of the beneficiaries as co-owners with each other. It's a recipe for disaster.
Yeah.
No matter how well the beneficiaries, the siblings at this point might get along, it's always the potential that they will reach some sort of a disagreement. And when they do, there's really not a lot of options to break a stalemate when you have co-owner disputes. You have to file a separate lawsuit to force the sale of the property, unless everybody agrees. So when you have multiple potential beneficiaries, likely the intention is going to be to sell the real property. Now, if one of those beneficiaries may be living in the property, there are options to allow that beneficiary to purchase from the other beneficiaries, basically purchase from the estate the real property, and that's a way to address that situation. Typically, though, even if you had an individual beneficiary, just one child, or children who all get along, in a lot of instances, their preference is to just sell the property and create the cash that will then be utilized to pay off these expenses and debts.
Right.
I have had circumstances where they elect to keep the property. The idea is that they're going to turn it into a rental property and then keep it for a period of time and then decide whether to sell it at a later date. And that's great. They certainly can do that. But what we've seen is, we saw a lot of this, by the way, in 2008, 2009, 2010, when the real estate market took such a bad fall. We had quite a few real properties, people who passed away, and the real property was upside down. And so we were really just selling the real property to get out from the mortgage. There wasn't anything that ended up getting distributed to the beneficiaries because it was solely to pay these debts. Not the preferred, not the way I choose to have it go, but it's
And
out
that's
of my
what kind of
control.
happens when you over leverage, you know, and then
Yeah.
the market takes a turn, and now you have to short sell the property, or it gets you know, foreclosed upon. So let's talk about the real estate sale aspect as far as a probate is concerned. So again, it starts with the same process. The administrator is appointed. Same thing. It's no different than any of the other assets. Do they hire a third-party appraiser to get an opinion of value of the home in addition to the real estate broker that's going to ultimately be selling the home? Let's delve into that specific real estate related process.
So the answer to that is no. When the administrator is appointed to administer the estate, the court appoints an individual called a probate referee. And the probate referee's task is to appraise the assets. Now, they're not going to appraise cash. We know what cash is worth. It's whatever it's worth.
Right.
We want to know what the value of the account was on the date the decedent passed away. You go look at the bank statement. Not a difficult process. But real property obviously does require an appraisal. So the probate referee's job is to appraise the assets, which includes the real property. They don't do an appraisal like what you and I would be familiar with should we be involved in a sale of real property, just a regular normal sale or even a refinance. The probate referee does not do an interior review of the real property. They drive to the property, they take pictures, they look at the general condition, they run comps in the area, and they come up with a value. It is not scientific. And I've had numerous instances where I've argued with the probate referee as to what the value was because I didn't agree. A lot of situations where that comes up is that there's deferred maintenance that is located inside the property that the referee just doesn't see because they're not going to get there. So what we do when we're looking at getting ready to sell the real property through the probate is we utilize the appraised value from the probate referee as a base. There is one significant difference or distinction in the probate administration with the sale where that value is actually really, really important. So when the administrator gets appointed, they get appointed with either full powers or limited powers. And this is under the Independent Administration of Estates Act. It's a portion of the probate code which governs what the administrator can do. The distinction between the individual with full powers and limited powers has, I would say, two major distinctions. Number one, we haven't talked about it, we don't need to talk about it, but the administrator sometimes will be required to post a bond. If they have full powers, the bond will likely be higher. If they have limited powers, it will be lower. The distinction being, limited powers is just that. The administrator is limited as what he or she can do without court supervision. Full powers, there's a much larger spectrum of what the administrator can do.
I see.
So when there's limited powers under the Independent Administration of Estates Act, it has its own sort of carve-out process with respect to the sale of real property. It requires that the property be listed for sale, a notice of sale be provided, it requires that bids be accepted, and then ultimately the bid that is accepted by the administrator gets submitted to the court for approval, and at the hearing on that sale, the judge actually conducts an auction and other overbidders are permitted to appear. How that relates to the value is this. When the probate referee appraises the real property, if the property is going to be sold through this confirmation process, the sale price has to be within 90% of that appraised value. And I don't remember if it's within 6 months or a year. The appraisal has to be within that time period of the actual sale.
Sure, so it has to be
it may be
rather
reappraised.
Right,
yes,
okay.
or it will require reappraisal. So I've had situations before where we've submitted our petition for sale knowing that it was not within the 90% number, and I've gone back to the probate referee and I've asked them to reappraise separately, knowing that we've listed the property for sale, we've done the very best we could to try and get the highest possible price. It's just not getting it, and we can't have the sale fall through because we can't meet the appraised value price.
Right.
So that's the carve out of that limited powers distinction. Other than that, the appraised value, if it's going to be sold through the administrator with full powers, that number is sort of a benchmark to shoot for. And what we do is, in order to ensure that the beneficiaries are given notice of what the sale price is and how it relates to the appraised value, when the property is ready for sale and an offer has been accepted, the administrator is required to notify everybody and to give all the beneficiaries 15 days notice, which says, these are the terms of the sale, and by the way, this is what the property appraised for. They may not correlate. They may be distinctly, there may be a huge separation between them, but as long as the beneficiaries are put on notice, if within that 15-day period they don't object, then the sale can go through.
So
if
they
object,
do have the right to object. One of
Yes.
one or more of the beneficiaries can say, "I'm not happy with this," or "I disagree." Do they have to give a reason as to why they're unhappy and why they disagree? No, it's just
no.
I don't like it.
And I've seen this before because I've
Yeah,
had
what happens
I've had
in that?
experiences where we believe that the administrator doesn't really have the best interests of the other beneficiaries in mind, right? It may be that it's one sibling representing the estate with the beneficiaries being he or she and the other siblings.
So
And
the
there's
administrator
dissension.
could also be a beneficiary.
Yes, oh, absolutely, absolutely. And whereas you would hope that they would want to maximize the value for their own benefit as well as the other beneficiaries, sometimes there's dissension and they just want to screw over everybody else. So they found the person across the street who says, I'll make a good deal for you. Well, there's benefit to selling it to the person across the street because I don't have to go through the process of listing. I can save on brokers' commissions, things like that.
Sure.
So there may be reasons why. So yes, when the sale is noticed, if the beneficiary looks at it and says, wow, they're selling it for $500,000, but the probate referee's appraisal was $1 million, they can object. Say,
Sure.
I don't really like this. And at that point, the administrator's option is to either cancel the sale or they can file a petition with the court and basically ask the court to give them permission to sell at that amount, and then they'd have to demonstrate why they took such a what seems to be a significantly undervalued price.
And that could be a circumstance even with full powers where the administrator might have to go to court to get court approval on something like this, where normally if there was no objection, there would be no need to go to court. So if all the beneficiaries are on the same page with what the administrator has been doing within that 15-day notice period, things can just move along smoothly. But they do have that opportunity to review everything, review the terms, and say, hey, I'm not happy with this. This doesn't seem right. We need to reevaluate.
Right. And you and I have worked on these transactions before where I say, as soon as you have a signed offer, let me know, because I need to do that notice. And if that notice doesn't get served and filed with the court, and that 15-day period doesn't even start, escrow will not close. Escrow is going to call the broker, and the broker is going to call the lawyer, and the question is going to be, where's the notice? And if that notice isn't served, the escrow won't close.
I think that's why the communication and the relationship between the probate attorney and the real estate broker is so important, because having worked with each other before, we do work as a team. You know, we are working together to help this family or this administrator on behalf of the beneficiaries do what's right. And as we know, in real estate deals, sometimes time kills deals. You know, I mean, you could have a great offer, you didn't post the proper notices, you didn't go through the proper channels, you didn't communicate with the attorney. Next thing you know, the buyer's upset, the beneficiaries are upset, and the deal falls apart, and that could have been totally avoided. You know, so I think it is really important to be on that same page and walk hand in hand together through the process. I'm
glad you said that, because I like people to like me. And
I like you.
I appreciate that. I like you too.
Thank you.
I've been in the situation where I'm the last person to know that the property is getting sold, and I get a call from the broker saying, okay, escrow is closing tomorrow, and they want to know where the notice is, they want to know where the letters of administration, they want to know the letter from regarding the estate taxes, so can you provide those? And my answer is, what are you talking about? How come nobody told me this was going on? You got to extend escrow because I have to give that 15-day notice. And in a lot of instances, I come out as the bad guy because the broker says, we're ready to go, but the lawyer is the one who's holding everything up. So,
just to be clear, I am not that broker.
No. No, and
just
that's why,
for the record, I am not that broker.
No, and that's why I like to work with the people that I know, trust, and have confidence in. In a lot of instances, when I speak with the client and they're looking to hire an agent, I would love to refer them to the people I work with. But sometimes they have people that they would prefer to use, whether it's the broker who sold their mother the house 35 years ago, whether it's a family friend or somebody who stopped by the house and dropped off, leaflets and pads of paper. And if they want to use that person, great. I certainly don't want to be in the position of trying to disrupt a relationship. But what I do tell them is, first off, I need to talk to them. I need to talk to them at the beginning. They need to understand what I do. They need to understand how we're supposed to work together, and they need to understand what some of these deadlines are. Because if any of those fall through, escrow isn't going to close, and I don't want to be the bad guy. Well, also, it's totally avoidable stuff, and that's the thing. There's no need to experience some of these issues that unfortunately commonly happen, and it's really just because of a lack of communication or lack of understanding, and that totally avoidable problems. Because it's a process.
It is.
It's all it is. It's
with
just a process.
Step by step.
Don't tell anybody this, but yes, there's a checklist. There's a do-it-yourself hotline. There are ways to do it where you can follow the checklist on your own. It doesn't mean you're not going to run into obstacles. It doesn't mean you're going to do it perfectly each time. That's what lawyers are for. And there certainly are nuances to the process. But yes, it is for lack of a better word, a step-by-step process that as long as you follow the steps correctly, you shouldn't have any complexities. People get an anxiety when they hear the word court. When they hear that there's going to be a third party with a robe sitting up on a bench in a courtroom who's going to be making some sort of a decision. That's when there's a bit of an anxiety. My job is to just guide them through the process in a way that's really as uncomplicated and really as comfortable and efficient as possible.
Yeah, having talked to our mutual clients, when they call me or I sit down and meet them for the first time, they just gush about you. They love you so much, and it's because you really do take the time to talk to them and explain things to them and really make sure that they understand what's happening. They feel like their hand is being held throughout the process, for sure.
I appreciate that. I hope so.
Yeah, absolutely. So going back to assuming the notice has been given, the 15 days has come and gone, nobody has objected to anything, or if they did object, the court came to some sort of a decision, what happens next in the sale of property?
Escrow closes.
Everybody gets paid.
It's that easy. Yeah. The distinction is, and this is a common misconception, is that when escrow closes, everybody gets their money. That's really not how it works. When escrow closes, the estate gets its money. So remember, I mentioned as part of the process of marshaling the assets, the administrator goes to the banks where there may have been bank accounts, liquidates those accounts, and creates an account in the name of the estate. Mm-hmm. The proceeds of the sale go into that account as well. And so that's the fund that is used to pay those creditors, if there are any, to pay the funeral costs, if there were any, to pay the costs for the process itself with the court, selfishly to pay the attorneys, to pay the administrator their compensation. This is what the fund that is used to pay all those expenses. Only once the administration is concluding and the court is given permission to distribute to beneficiaries, that's when those checks actually get written.
So there is definitely a hierarchy of who gets paid when.
Yes, oh,
right?
Absolutely.
Yeah.
Absolutely.
Starting with the creditors. If there was a mortgage on the property, escrow will have already ordered a payoff demand. That would have been paid through escrow. If there were delinquent property taxes, that would have been paid. And then other creditors, like credit card debt,
Yes.
auto loan, all that.
Yes.
All that kind of stuff.
Yes.
Okay.
All kinds of revolving credit, Verizon wireless bills we've had to pay, past due water and power. Those are all the types of traditional creditors that would get paid. Also taxes. As part of the notification to creditors, we have to notify the Franchise Tax Board, California Franchise Tax Board. We have to notify the California Department of Healthcare Services if there were any Medi-Cal benefits that were provided to the decedent before he or she passed away. They would have a claim. The Franchise Tax Board and Department of Healthcare Services have a superior lien or superior right to repayment over Visa, Bank of America, credit cards, things like that. They have a priority. The other priority, and the probate code outlines the order of priority for repayment. Funeral expenses get a priority. The attorney's fees, the administrator's fees get a priority. Beneficiaries, even though they are the ones who ultimately will benefit from the distribution of the assets, they're last. They're the ones who get whatever's left when everything else is paid.
And how long does that process take after escrow closes and all the creditors have already been identified up front? So there should be no new creditors coming out of the woodwork. After escrow closes and from that point on, how long does that process usually take for the beneficiaries to see whatever's coming to them?
For that question, for this discussion, we are going to assume two things. We're going to assume, one, that the 4-month creditor's claim period is expired. So there are no new creditors. If there are any creditors that come up after that period, they are barred from asserting their claim. So we're going to assume that that 4-month period is expired. We're going to assume that any creditors' claims that came in were allowed and have either been paid or will be paid as soon as escrow closes. We're going to assume that we've received from the California Department of Healthcare Services a letter indicating that they don't have a claim. And we're going to assume that the Franchise Tax Board has also issued us a letter saying they don't have a claim.
Okay.
With those assumptions being made, we're basically looking at what could be between 3 and 4 months to finalize administration of the estate. At that point, the administrator has a responsibility to provide what's called an accounting. And accounting is not necessarily just a QuickBooks printout of what's been going on. It's actually a very specifically formatted document which addresses what the income, receipts, disbursements, expenses, asset values, etc. of the estate were from beginning until end. That accounting is provided to all beneficiaries and it's submitted to the court. It's submitted to the court with a request that the administration be concluded, that the assets be distributed, that the administrator and administrator's attorneys get paid, and that distributions be made to the beneficiaries. So once the escrow closes, it's really a function of how quickly can that accounting get prepared. Now, separate from that, all the beneficiaries are permitted to waive an accounting. And so they can say, you know what, we don't need this full formal document specifically formatted and specialized for the probate code requirements. We trust what you did. In a lot of instances, when I'm asking the beneficiaries to waive an accounting, I'll provide them with all the bank statements. They'll see everything. Basically, I'll say to them, this is all the information we would use to prepare the accounting. So could you save us the hassle and the expense of paying for the accounting and just agree to waive that account? If they do, we still file what's called a final report with the court. Again, it identifies all of the transactions, everything that basically took place during the administration. It identifies what the administrator and the administrator's attorney's compensation calculation is. It identifies who is supposed to be inheriting, and that gets set with the court. And at that point, once it's filed, it's about 75 days here in Los Angeles for a hearing date. So what I tell my clients is, as soon as escrow closes, that 4-month period is over, all those other assumptions are cleared, we're looking at about 75 to 90 days until we're finished completely.
And if those assumptions, let's say, have not been fulfilled, it could be longer.
Yes.
Okay.
Yes.
Potentially months.
Correct.
Months longer.
Situations that could dramatically increase the length of time that the process takes. Number one, we experienced this a tremendous amount right after COVID, which is real property that we can't sell because there are people living in it. That dramatically lengthened some probates because we couldn't evict people.
Right.
They knew we couldn't evict them, so a cash for keys type of arrangement wasn't going to work. And we were there holding an estate open because we couldn't liquidate the property to pay off creditors or to pay attorneys or whatever it may be. So that extended a couple of probates that I had in a tremendously long amount
Are
of
there
time.
like fees or penalties that the estate will incur in a situation like that? Okay.
No, not the estate.
That's good. Okay.
No. The estate does have to report back to the court. When the administrator gets appointed at the very outset, the court sets a deadline date. It says, by this date, you should have filed your final report, your petition to close. If you haven't filed it, then you should at least file a status report. Tell us what's going on and why you're not done and why you need more time. Typically, you're looking at about 14 to 15, 16 months is what the court will give you. And that's a good amount of time. COVID, that was not enough time.
Not enough, yeah.
And so there were quite a few of my administrations that got extended multiple times because we had tenants in the property that we couldn't remove. If there are creditors that are out there that we reject, they have an ability to pursue a separate civil claim on the rejected claim. That will extend to probate because we can't close while the claim is still open. If there are tax issues, I've had a few recently that we worked on with our friend Dan Schwartz, where the individual passed away and had not filed tax returns for the last 3, 4, 5 years. Those all need to be addressed and cleared.
Yeah.
In a lot of instances, there's no information to do that because the administrator doesn't know whether their father, mother, whoever it may be, the decedent had made a lot of money, where the money was,
Right.
that type of situation. So those are the types of situations that could extend the probate longer than being ready to close, pretty soon after that 4-month creditor's claim is expired. But if you were to take the process from end to end, using some of the timelines we've already discussed and understanding how the court works as far as its efficiency, I tell clients the easiest process, the most straightforward, no complexity at all, you're looking at 10 months.
10 months, okay.
As minimum, because there are aspects of it that I can't control.
Sure.
I can't control that 4-month creditor's claim period. I can't control how long it takes to get into court. Those are out of my control.
Right. Wow, good to know. Question for you. How can somebody avoid probate?
Why would they want to do that?
Humor me.
You didn't talk about my favorite part of probate.
Let's talk about your favorite part. Oh,
How I get paid.
which is obviously by doing probate. I know. I'm sorry. I'm like bringing up how to avoid working with Rob Cohen.
No, not avoid working with me. Just the probate process. Just real quick, because this is a question that always comes up: is how much does this cost? The answer is I don't know. It's a calculation. So the attorney and the administrator, they both get compensation, and they both get compensation at the same calculation. They get paid based on the value of the assets of the estate. It's a calculation based on, it's 4% of the first 100, 3%, etc. So what I can tell you that if it's $1 million, it's $23,000 in fees and costs, fees, just attorney's fees, and the administrator has the same. That's separate from filing fees, publication fees, probate referee fees, etc. So probate, notwithstanding the possibility of it being an incredibly lengthy and obviously court supervised, there is that aspect. The fees can be, to some extent, oppressive to some people. In a lot of instances, especially if you have real property that is heavily encumbered, if you have to sell the property, there may not be as much cash left over to distribute to beneficiaries because you're paying the attorneys based on the gross value, not the net value. So yet another reason why people do like to attempt to plan accordingly to avoid the probate process.
Right.
Not least of which is what I tell people all the time: we want to spend our lives as much as possible without the court being involved. So there are attorneys who do what's called estate planning, and a lot of that is for the purpose of attempting to avoid the probate process. Establishing a trust, moving assets out of the individual's name into the trust can go a long way to avoiding a probate administration.
Makes sense. And short of having a trust, it seems like from what we were talking about in the beginning of the conversation, just having a will that specifies certain people, certain things, certain of your wishes could definitely help make the process a little more timely, perhaps go by a little more easily in terms of you, the decedent, having already made certain decisions that won't now have to be left in other people's hands.
Right. The key distinction of the will versus no will. The process is the same if it's just a will. The distinction is control, the ability to identify who you want to inherit. If you have no will, this is not a terminology that I coined, it was a friend of mine coined, you get the government's plan. The government decides who's going to inherit. And it is solely biological. Nearest living biological relatives, whatever class that is, whether it's children, siblings, whoever the cousins, whoever the closest living, biologically, not residentially or geographically, they will inherit whether the decedent wanted them to or not. And this is something that a lot of my clients struggle with, especially when they come to me with an estate where the individual had no will or trust. Is, okay, so you're going to have to abide by the government's plan, which means it's going to be distributed amongst, let's say, the 3 children. The 3 children? Yeah, the 3 children. He did not have a surviving spouse when he passed away. He had 3 children. It goes to the 3 children. Okay, but he and our other sister, they were estranged. Okay, they hated each other. Okay, she didn't invite him to her wedding. Okay, she had grandkids. She had kids. He never saw his grandkids. Okay, she's still going to inherit her 1/3.
Yeah.
I cannot change that. That's what the government plan is. That becomes quite difficult for people to grasp because the California Probate Code doesn't take into consideration any of those types of emotions or intentions. It's irrelevant. So even if it's just, I don't know that I want a trust, I don't want a trust, I'm afraid of a trust, I don't understand a trust, but I know what a will is, even at that point, you may not void a probate, you likely wouldn't avoid a probate, but at least you can have some say in where your assets go.
Which I think will probably give you peace of mind while you're alive. First of all, while you're alive to have these relationships with whomever is important to you, and give you the peace of mind that in your absence, they don't have to worry about now making these decisions, because you've already established that for them. Now, when you say biological, this might be getting too technical, but what if there was like an adopted child, like are they, like as a beneficiary, it's not their biological child? Am I getting too technical? Like if it's a kid?
This is a good question. Legal adoption is considered for the sake of the probate code as if they were the biological child.
Okay.
Legal adoption.
Legal adoption.
So if a decedent went through the process and formally adopted a child and had 2 biological and 1 adopted child, but it was a formal adoption, then it would be amongst the 3 of them.
Okay.
Similar, or by reverse, if the decedent had a biological child who he or she gave up for divorce and was gave up for adoption and was adopted by somebody else, that terminates that biological child's interest in the estate because they now have adopted parents from whom they would be able to inherit.
Oh, so interesting. Okay, good. I'm glad I asked that question.
Yeah. And interestingly enough, there's actually a specific code section in the probate code which addresses that.
I'm sure there is. I'm sure there is. Let's talk about a will.
Yes.
Okay. What are the important elements of a will? Like, what would distinguish a good will versus a bad will, or a really useful will versus one that really doesn't establish anything? Have you seen, are there different grades of what goes into a will and what makes it good?
I will tell
and
you
useful?
that the distinction regarding the wills only comes up if it's being challenged.
Okay,
So
explain.
if there's a concern about the validity of the will, the mechanism of its preparation, the mechanism of its execution, those become primary concerns. There are sections in the probate code which govern how a will should be written.
Okay.
But there are distinctions. And I had an appointment with a client the other day, and I said, the world of probate, because all these questions she was asking about her father, who had passed away intestate without a will, was asking all these questions. And my answer was, there are distinctions. So with respect to a will, there are distinctions. A will can be a formally prepared will, typewritten out, and it can have vast number of provisions and conditions. It will not be valid unless it complies with the execution rules, which means it has to be signed by the individual themselves, and it has to be witnessed by two people who were both there at the same time that the individual signed it and knew that they were watching him or her sign his will. Very specific requirement. If it doesn't satisfy those conditions, it will not be a valid will, regardless of how well it was drafted.
It could look as formal and professional,
Correct.
but if it is not signed by the actual person
And
writing the will
witnessed by
and
the two
witnessed
people.
by two people
Right.
who know that it is a will, like they know the intention of and the purpose of this document.
Correct.
Now these two people, can they be any two people? Does one of them have to be a notary? Can
No.
it be two guys off the street?
Yes.
Oh, okay.
The terminology is they need to be disinterested. They can't be beneficiaries of the will itself.
Oh, okay. So
Right.
that is another qualification.
Right.
It can't be, your kid who might be your
Which makes
beneficiary.
sense, right?
Yeah.
I mean, if you think about it, Dad signed a will and the witnesses were the two children who were going to inherit everything to the exclusion of the third child. Wow, sounds like there may have been some influence. It's not that you would automatically assume there's influence. The court would look at that and be concerned about the validity of the intention of the decedent.
Sounds like a TV drama.
Right.
Yes, waiting to happen.
But this is
Yeah.
a common thing that comes up.
Okay.
I've seen this a lot. People who get their wills notarized, not a valid will. One notary is not two disinterested witnesses.
It could be two notaries, and that would be
Sure.
fine.
Absolutely.
Right, but it has to be two
Right.
disinterested witnesses.
Correct. So that's the what we could say the prima facie look of a will, right? 8 pages long, breaks up every single piece of property they own and who they want it to go to, who's the executor, whether they have to post a bond, where they live, all this. It could be all those things. And if it doesn't satisfy the requirements of the execution, it will not be admitted to probate. Now, on the opposite side, I've had wills that were written on cocktail napkins.
Okay, I've heard of that,
Yeah.
and I wanted to know, is
Sure.
it a valid will?
Yeah.
If that's cocktail napkin, it has been signed by the person making the decisions, and do the two witnesses, I'm assuming
no witnesses.
they have to,
No witnesses. So
okay.
the alternative to the formal two-witnessed will
Okay.
is what's called a holographic will. Holographic means it's all in the individual's handwriting. Now, let me qualify that. It's not all. The material terms are in the individual's handwriting and are signed by the individual. And typically you would have it dated because there is an issue of questioning the validity of a holographic will if it's not dated, because there may be subsequent wills that were dated and then you have an issue of timing of when it was done. So if it's not dated, you at least have a mechanism by way to determine when it was possibly executed. But that's it. I've had people write wills this is my last will and testament. If I die, I leave everything to my brother, period. And that's it. Cocktail napkin, ripped off piece of paper, notebook paper, whatever it is. As long as the material terms are all in the individual's handwriting and are signed, it will be, in a lot of instances, again, barring any objection or attempt to contest it, it will be admitted as a valid will.
Oh, wow.
Yes.
How often, I don't even know if there's a statistic for this, but just, I guess, in your experience, do you often find that wills are contested? Like more than 50% of the time, or rarely ever? Or
No, not that much.
No.
I can't give you a statistic.
Right.
Less
No,
than 50% of the time. I will say the vast majority of wills or trusts, the administrations are fairly straightforward. Yes, there are instances in which they get contested, whether there's a belief that the will or the trust was a product of undue influence or duress or lack of capacity. Those are very common as well, those contests that are brought, and I handle a fair amount of those as well.
Yeah, in a like a holographic will situation where there were no witnesses in the person's handwriting, then to confirm the validity of that, what happens? Handwriting samples?
Yeah.
They oh, okay.
Yeah,
okay.
that's a great question. So what you would do is when you submit the will, the holographic instrument to probate to be admitted, there's also additional form that you would have to provide, which is a proof of holographic instrument. And it's somebody who is well familiar with the handwriting, would sign a document under penalty of perjury saying, I've reviewed that will. This is the handwriting that I'm familiar with. I've known this individual for X number of years, and that will be the supporting evidence. Now, obviously, if somebody contests it, then you have the ability to do handwriting experts and things like that to determine if the handwriting was accurate. I have one right now where we're arguing over a handwritten will, but we know for certain that the signature on the will was not the same as the person who wrote out the actual words. And so we objected to it.
Yeah.
We've claimed it may be holographic because it's not the full typed out, formatting. But we know for certain that the material terms are not in the handwriting of the decedent.
And that is a requirement. The handwriting
Yeah.
of the decedent
Yeah.
and the handwriting of the material terms has to
Correct.
be of that.
Correct.
The same.
Now
hand
the
of
other side
decedent.
has argued that it was done at his instruction. He was in the hospital. He asked somebody to write it for him. I'm
like
not
he was
100%.
incapacitated to be able to.
Incapacitated is a bad word because if you lack capacity, you don't have the ability to write the will. So it could be, we've seen these situations before. People that are in the hospital, they're not able to write. They tell somebody, I want you to do it, and then they just do. This is like, television and movie stuff. They sit there and they just draw an X.
Right.
They can do, you can execute a will by a mark. There are requirements, there are specific requirements to that. But I think in this instance, what they're contending is that he wanted somebody to write the will. This was the person he designated to do it for him, and they're trying to get around the requirement that the material terms be in his own handwriting.
This might sound like a stupid question, but we have technology at our fingertips. We all walk around with cameras and cell phones, and our phones are mini computers that can do everything. In a situation like that, would video evidence of the person speaking, giving instruction to a loved one or a friend to write this, would that potentially hold up in court? Would that be helpful?
Yes, that would go towards the burden of proof. So if you are submitting this document for admission to probate and somebody contests it, then yes, that video evidence would be assisting in the proving the will process, right? The individual who is attempting to submit the will to probate has the burden of proving its legitimacy. That type of evidence would be supportive of that, yes. But it's not a will. So just me, we're sitting here, if I were to say to you, Christina, when I die, I want you to have everything. That's not a will, right? There's no such thing as an oral will. Well, actually, I take that back. This is a really, really, really small nuance.
Let's go. I'm
Very
excited.
few people know
Let's
this
hear.
because for whatever reason I was actually paying attention that day in wills and trusts. There is
You were paying attention in law school?
just one day.
Wow.
Yeah.
I won't tell anyone.
You could certainly. My wife doesn't hesitate to hold this over my head. So my wife and I, we met in law school. So she's now my law partner. We met in our wills and trust class. She got a better grade than I did. So there is a one known instance or one designated or identified instance, not in California that I'm aware of, that allows an oral will. And an oral will has a terminology, it's called a non-cupative will. I don't know why, but that's what it's called.
Okay.
And the instance in which it has been identified as being legitimate is in wartime. So the vision I have is soldiers, one is dying, whatever it may be, and says to the other, I'm not going to make it. Please make sure that my mother, gets my, whatever it may be. That, and I don't believe it's in the state of California, but I believe that that is an instance in which an oral will may be a valid testamentary disposition. Other than that, no such thing.
Wow.
So us having our video talk here and me saying that, which I, by the way, what I just said, I expressly revoke. It's not.
Sound like such an attorney.
It's not a I don't want this being used against me 50 years from now. Not a legitimate testamentary disposition.
Wow. This has been a fascinating
I hope
conversation.
So.
No, I mean, it really has been. I'm just like so interested. I'm like, what else does Rob have to share with me? And as we wrap this up, I'm sure there's so many other details and a bunch of other avenues that we can go into that are a lot more technical. But as we wrap this up, is there anything else that's like really important that we haven't addressed that you would like to shed light on, whether it's some final thoughts or maybe even something completely brand new that we can just introduce into the video that we haven't discussed? Because sometimes I just, sometimes I don't know what I don't know.
That's fair.
So I want to ask you.
It's such a wide spectrum of topic, and the California Probate Code is like this large, so I'm not going to try and pull anything out of that.
Yeah.
What I will say is this, for anybody watching, and this is what I tell anybody who asks me. I do probate administration, so I know how the court process works. I do trust administrations also. I do the litigation. Number one recommendation, get a trust done. People have asked me all the time, well, I don't know if I have enough assets to necessitate a trust. I'm going to tell you there's a distinction, okay? It's a distinction. If you have anything more than $180,000 in probate assets at this point, that's the jurisdictional amount, 180 and some change. If it's less than that, and this is not counting real property, if it's the combined of your assets, so you have to include real property in that. If real property is part of that, you're not going to qualify.
Right.
If you're less than that amount, if you have a will, a trust, it's really not going to address anything because you won't need to go through a formal process. There are small estate processes you can do. It's not formal. It's not court supervised. If you have anything more than that, anything more than $188,000, you have real property, you have children, minor children, get an estate plan done, do it right, and get a trust. Okay, I will be fine if I don't have if 90% of the population gets a trust and doesn't need a probate administration, I'll still be fine, okay? Don't worry about me. But my recommendation always is do everything you can to keep the courts out of your life. So not only does an estate plan, if you do it properly and you fund your trust correctly, not only will it help you to avoid probate, it will help you to avoid conservatorships, it will help you to avoid guardianships. Now, guardianships are the appointment for children under the age of 18. Now, when I say it'll help to avoid guardianships is this. If a minor child is a beneficiary of your estate, is going to be given assets, they cannot take possession of those assets until they're 18 years old. If they're minors, the court may require a guardian to be appointed, and that guardian is court supervised, has to provide accountings. There's a completely different set of requirements for that. If you create a trust and you have minor children, you can control who's in charge of the money, when the children get the money, what they can use the money for. It is a great tool to have when you have children. As well, pardon me, it's a great tool to have for the situation in which you yourself might have moments or instances of incapacity. If you go into a coma, if you have dementia, any of those situations, you will have, with this properly created and executed estate plan, you will have documents in place which will instruct how you will be taken care of, that it won't require the court to get involved. We've all seen the disastrousness of the court system, especially the conservatorship program, with the Britney Spears case. And they've done a lot of work lately to try and address the errors that may have occurred during that. but that was a public process where an individual was subject to the taking of her ability to make her own decisions. And if she'd had documents in place, most of that could have been avoided. We're not Britney Spears, I get that, but nevertheless, we don't want the courts to be making those decisions. So get a good estate plan, get the right attorney, we know lots, obviously, have the documents done properly, review them periodically. That is going to make not only your life easier and more comfortable, and hopefully you'll be a little bit more set and comforted that things are in place, but then it will also ease the transition when you do pass away to administer the estate moving forward. Yeah. That's my number one recommendation to everybody.
Mic drop. That's it. Thank you so much.
Thank you.
This has been so insightful. You are just wonderful. Such a pro at what you do. Thank you so much to you, the viewers, for tuning in. I hope you learned a lot. As I always say, I am here for you. I am a resource for you, real estate or otherwise. I am fortunate enough to know incredible experts in their professions, such as Rob Cohen. Until next time, take care, and I'll talk to you soon.